Hello, I'm Alison Colley from Real Employment Law Advice, and today I'm going to be talking to you about the furlough scheme as it has been extended from the 1st of November. There was guidance published recently, so on the 10th of November, which explained a bit more detail about the scheme and the scheme rules. So I'm going to cover off some of the key points that both businesses and individuals might be interested to know. The first thing is that all businesses can utilise the scheme. There is no requirement to show that your business has had a loss as a result of COVID. You don't have to be closed in order to claim, and you do not have to have used the scheme before. So it could be your first time of furloughing staff, and you can utilise the scheme as it is available currently. There is also no criteria to assess business eligibility, so you need only make a claim and follow the scheme rules in order to apply. The second thing is that the only contribution that employers have to make is to national insurance and pension contributions. So you can claim 80% of pay for those furloughed employees. Those of you who have used the scheme before will recall that it started to taper away so that employers were paying 10% and then 20% towards wages. Under the current scheme, which came in on the 1st of November, you can claim 80% of pay. You just need to pay that NI and pension contribution. Employees don't have to have been furloughed before in order for you to furlough them now. Again, under the previous scheme, you'll recall that it was a requirement that employees had been furloughed before, and that was introduced, and there was a minimum period of time that had to have been furloughed in order to continue to use the furlough scheme for them. So employees can be furloughed for the first time now. They don't have to have been done before. As long as they were on your books before the 30th of October, then you can furlough them. All you have to have done is filed the RTI submission by then for that employee. Employees can be furloughed or flexibly furloughed. So you can utilise both the full furlough scheme or the flexible furlough scheme. So if your business has had to close, for example, due to the lockdown in November, then you may want to fully furlough your staff. And then if you can reopen again after the 2nd of December, you might want to consider using the flexible furlough scheme, so to cover some wages where you may have a reduction in turnover, for example, or you have restrictions on when you can trade. So you can use both the full and flexible furlough scheme now, but you should ensure that you keep good records of the hours that are worked by employees and the hours that are not worked. So those hours that are not worked are the ones that you would be claiming for. Because it's going to be flexible and because the sort of rules around the scheme are less involved, there may be more scope for HMRC to audit and to look into things. So I would recommend that you keep good records of when someone is furloughed or flexibly furloughed. There is now no maximum amount of employees who can be furloughed under the scheme. Previously, there was a cap put on the number that you could furlough at any one time, and currently that's not in place. So you can furlough the whole workforce if necessary, and there are no limits on the numbers. There are now monthly deadlines for making a claim. So claims must be submitted within 14 calendar days after the month they relate to, unless it falls on a weekend, in which case it's the next day. So you can't let your claims lapse or drag on past the end of the month. So for those people who are responsible for putting those claims in, for collating the information required, it's important that they have all that information and are ready to submit the claims within 14 days. There is no minimum period for furlough. So again, you may recall that there was a 3-week minimum period for full furlough when the scheme was first introduced. There is now no minimum period. So you can furlough someone fully for a week, for example, then have them work flexibly for 2 weeks and then fully furlough them again. It all depends on the needs of your business, what staffing you need and what you can afford. But if you are using the scheme to go from full furlough to flexible furlough, it's important that you include this in your agreements with the employee. So for example, if you are furloughing someone fully for November because you're closed and there's no work for them, if you then go on to flexible furlough, let's say from the 2nd of December, it's important to reiterate that in writing to the employee so that it's clear that they were furloughed fully and then moving to flexible furlough. That's my advice in relation to how best to record it in the agreement with the individual so that employees understand exactly where they stand and what's happening. Employees returning from maternity leave can be furloughed if you need to, but if they want to return early from maternity leave, then they must give the minimum of 8 weeks notice in order for you to claim for them under the scheme. Now, employees, if they want to return from maternity leave, by law are required to give 8 weeks notice, but you can agree between you a lesser period if you want to. So that's at your discretion. But what you can't do is agree a lesser period and then claim furlough for them. So this is to prevent employees taking advantage of the more beneficial money available under the furlough scheme, so ending maternity early to claim the furlough pay. Once again, you must notify employees in writing about the furlough scheme, what you're doing, and so it says there to be eligible, an employer must have confirmed to the employee in writing that they've been furloughed or flexibly furloughed. You must keep that letter or agreement for 5 years. And under the scheme rules, you're not required to get the employee's response. So the employee doesn't have to respond positively to say they accept the change. However, our advice is that you should do so. So from an employment law perspective, it's important to remember that when you are furloughing or flexibly furloughing someone, you are agreeing between you to change their terms and conditions of their employment. And those terms and conditions could already be in writing by way of a contract, or they could be by implication by how you've agreed to work in the past. So you are agreeing a temporary change to their terms and conditions. So in my view, from an employment law and employment relations perspective, it's really important to get the employee to respond. Now, we've created a template letter for employers to use, which is available for free to download from our website, which is at realemploymentadvice.co.uk/DIY-documents. And in there, you'll see that we've included a little paragraph at the end where we've asked employees to respond in writing by email. So they cut and paste that, respond to someone within the organisation, and that's sufficient, in my view, for them to confirm their agreement to the change. But for the purposes of your furlough claim, you don't actually need them to do that, but it is good practice, as I say, both from an employee relations and an employment law perspective, to get that in writing. One of the biggest questions that we've had throughout the furlough scheme, both the old and the extended, is in relation to holidays and what you do around holiday and holiday pay. So under the extended scheme, employees can continue to take holiday during furlough time, and you can continue to claim furlough pay for that time, so the time that the employee is on holiday. But when an employee takes holiday, you must pay them at the full 100% rate of pay. And holiday pay must be calculated on the average of the last 52 weeks' pay. Now, this may mean that what you have to pay employees differs from what you can claim under the scheme. Now, what I advise employers to remember is that your contractual obligation to your employee sits over here. In the one hand, you're required by law and by agreement to pay them something, okay? And then what you can claim from the government sits over here. So you can claim some money back by way of the furlough scheme grant, if you like, to cover some of those wages. Now, the 80% that you can claim is based on the formula that's within the scheme rules, but 80% of the 100% holiday pay may be slightly more than what you can claim from the government. So it's really important to keep that in mind here when it comes to calculating holiday pay. It is different to your calculation in relation to the furlough scheme. You can still stipulate that employees take holiday during furlough, either by giving them notice in accordance with the contract or your policies. So it might already say in your contracts, for example, that employees may be required to take holiday as stipulated by the employer. Or if you don't have that in your contracts or procedures, then you can require them to take holiday by giving double the notice of the amount of time you want them to take. So, for example, if you want them to take 2 days holiday during furlough, then you're required to give them 4 days notice of that holiday. The guidance specifically states that employees should not be placed on furlough for a period simply because they are going on holiday. So it's not a way in which employers can recover money that they would otherwise have to pay for holiday. Of course, if an employee is furloughed for a longer period of time and they want to take holiday, or you ask them to take holiday in that time, then that's fine. But you can't just have a period of furlough claim that corresponds with holiday. Redundancy and notice. So under the furlough extension scheme and the guidance, you can currently put employees at risk of redundancy and give notice to terminate for reason of redundancy and still claim furlough pay. Sorry, there's a bit of a typo there. So it is put employees at risk of redundancy and give them notice. So under the job support scheme, which was going to be the replacement for the furlough scheme, there were restrictions on this, but under the furlough extension, there are no restrictions. You can claim furlough pay for a period of notice for November. So if you give an employee notice to terminate their employment, let's just say you're required to give them 2 weeks notice, you give them 2 weeks notice that their employment will end on the 30th of November, and that's by reason of redundancy, for example, you can still claim the furlough pay. But what it says within the guidance is that for claims from the 1st of December, there will be further guidance on this. Again, I don't have a crystal ball, but my prediction is that there will be some restrictions on what you can claim for notice and redundancy periods going forward. I know a number of employers have reinstated employees who were due to end on the 31st of October so that they could take advantage of the furlough scheme and continue to pay employees 80%. And that's fine, but I just think that from the 1st of December, they're going to restrict this, and so potentially say that if an employee is serving notice, you can't claim furlough pay, so you'd have to pay them at the 100% rate yourself. It's just something to be mindful of there. If, of course, you have reinstated employees who would otherwise have been dismissed by reason of redundancy at the end of October, you must ensure that there is a clear end date to their employment, and that the reason for the termination is stated very clearly, i.e. for reason of redundancy. So there can be no doubt about when their employment will end and the reason for that. I would ensure that it's set out in writing what you've agreed, and to be very clear with the employee that this isn't an open-ended thing, that actually their employment will end, and these are the reasons why, as previously communicated to them, of course. Now, the calculation of wages is one of the main issues that we've been asked about recently, particularly as the initial guidance on the scheme that came out wasn't very clear and didn't contain the detail. Well, for those employees who were on fixed pay, the starting point to work out what their pay is to understand what the correct reference period would be. So, for employees who were employed with you prior to the 19th of March, it's the last pay period ending on or before the 19th of March is the reference period for working out wages for the purposes of making a furlough claim. For employees who have been employed after March, the reference period is the last pay period up until the 30th of October. And of course, if a fixed paid employee has done any overtime in that time, then that can be factored into your calculations. For those whose pay varies, again, the reference periods are the same. So for employees who are on the payroll prior to March, then it's looking at last year's wages in much the same way. Actually, it's probably exactly the same way as under the old scheme. That's how you work it out. The difference in the scheme is for those who have started to work with you after March, and then you take into account 80% of the average wages payable between April and November. And for employees who have variable hours, you have you complete a similar comparison in relation to working out their usual hours. The reason why this issue has come up in relation to the calculation of wages is because there are a number of organisations and businesses who have made changes to pay or hours in the period between furlough and opening, for example. So there may be employees who have reduced their hours, so they've gone part-time, or they've taken a pay cut because of changes in the business. Or you may even have employees whose wages have increased in that time, for example, because of the national minimum wage rise earlier this year, or just because part of your payroll processes. Now, it means that where there is a disparity between current wage and wage prior to March, for those longer term employees we're talking about here, those who've been with you prior to March, there will be a difference potentially in what their actual pay now is and what the furlough claim pay will be. So you may find that some employees are better off because furlough pay is based on pre-March pay. If their pay has gone down, then they'll be better off. And those employees who have had a pay rise, for example, who may be paid more now than they were pre-March, will be worse off. So you need to keep that in mind when you're deciding what to do in relation to pay for them. So if you would ordinarily just pay 80% to the employee, so what you can claim, for those employees whose wages have gone up, 80% of pay from March may be less than 80% of pay now. So you can decide whether you want to top that up so that they actually get the full 80% of their current pay. But it's just something to keep in mind because of the different scheme rules and how much further along we are and how things may have changed in the last 6 months, that there may be these differences, and you need to make sure that you're clearly communicating that to employees. In relation to the calculation of hours, so for those employees who are being flexibly furloughed, it's important to understand what their usual hours is versus what the hours they are currently doing. And there are a number of worked examples and clear guidance on the .gov website. I haven't included it here because it can get quite complicated, so I would recommend that if you are trying to work out usual hours, you have a look at that. And of course, if you have employees who have been furloughed previously, you might be able to use those previous calculations for those that might make it simpler for you. I just want to finish by talking about some other notable points in relation to the furlough extension that employers and businesses should be aware of. The first is that under the guidance it says that there will be a public register of companies who claim under the scheme after the 1st of December. So if yours is a registered company or a limited liability partnership and you make a claim, then you'll be listed and it will be available publicly. They haven't stated why that is and why they're doing it now. I think it's possibly for fraud prevention and maybe to even discourage companies from claiming if they don't need to, because publicly they will be seen that they need the help. Who knows? But it's something to note there if you are going to be claiming after the 1st of December. There will be further changes and a review of the scheme, so it's completely unrealistic to consider that the scheme will remain as it is, which is quite generous and quite flexible for November while we're in lockdown, further than potentially January. There will be changes to the scheme, I'm sure of that, unless, of course, we find ourselves in another period of national lockdown or further restrictions. My view is that it will potentially move to a more towards the kind of job support scheme rules that were due to come in obviously on the 1st of November, where there is support available for those businesses who were impacted, or perhaps if we go back to the tiered system in certain areas of the country where businesses have to close. Who knows? Again, I'm speculating, but it's important that you keep that in mind. The other point I want to make is about the job retention bonus. Now, you'll probably be aware that employers who had previously furloughed an employee and had retained them up until January would have been entitled to a £1,000 bonus per employee retained that was going to be paid in February. Now that has been postponed. It will be reinstated in the future, but who knows when, or in what form, or how it will work, or how much it will be. So there were a number of businesses who were banking on that money and had budgeted for it, but my advice now is to don't bank on it, and certainly don't budget for receipt until we know more. Finally, I just want to highlight that we have a number of resources for you. This is an ever-moving entity. Things are changing all the time, as they have been since March. But we do offer a fortnightly newsletter by email where we cover a number of points, both furlough related and employment law related, which is free. You can sign up online. We do articles and videos like this one. If you want up-to-date information as soon as it's available, then you can follow me on LinkedIn or connect with me. It's Alison Colley, and just search Alison Colley on LinkedIn or Real Employment Law Advice for the firm. I also have a fortnightly podcast where you can listen to updates that are available. We've got the YouTube channel and various social media for any updates that you may need. If you have any questions about anything that I've covered today, then please get in touch. You can email me. It's alison@realemploymentlawsadvice.co.uk. You can look on our website, which is realemploymentlawsadvice.co.uk, or you can give us a call in the office on our head office number, which is 01983 897 003. We're always happy to chat to you and answer any questions that you may have. Of course, if you like this video, please do like it and subscribe. And we're doing more and more videos and updates for businesses and individuals as and when things happen. So subscribe to get those notifications. And of course, if you have any questions or comments, you can leave them below, and we'll certainly answer those, and we love to hear from you. So I hope that you are staying safe and that you have a positive and productive week.